1954, a West German courtroom. The walls were new plaster over old stone, the Nazi eagle chiseled away but still faintly visible as a ghost outline above the judge's bench. On that bench sat Dr. Karl Emge, Landgerichtsdirektor, presiding judge at the regional court. He adjusted his robe, shuffled the day's docket. Petty theft. Illegal currency transactions. One case of assault. Routine work in a new democracy. On paper he was born 1902. Doctorate in law, University of Heidelberg. Judge since the late Weimar Republic. Cleared by denazification as Mitlaufer, a mere follower. In his private notebook, locked in a desk drawer, he wrote a different summary. They burned my past from the archives, but not from the eyes of those who remember. Because before he presided over minor thieves in the Federal Republic, he had signed death sentences for racial defilement, prison terms for undermining military morale, forced labor for listening to foreign radio. Forced labor for listening to foreign radio. He had been a judge under Hitler. Now he was a judge in Bonn's Germany. The law codes had changed. The hands that held the pen had not. Before 1933, a loyal servant of the law, whatever it was, Karl's career began in an era when the gravest worry in court was political street violence and economic collapse. In the late 1920s and early 1930s, as a young assistant judge, he believed in the supremacy of written law, the independence of the judiciary, the dignity of the robe. He watched Weimar democracy stagger under hyperinflation, political assassinations, emergency decrees. In the judge's lounge, colleagues muttered that the Republic was too weak, too permissive. Some sympathized with right-wing parties, some with the old monarchy. Most agreed on one point. Whatever government we have, we will apply its laws. We are jurists, not politicians. This self-image as neutral technicians would later become the alibi of an entire profession. In 1933, when Hitler came to power, Karl did not join the early wave of Nazi enthusiasts. He did not need to. The regime reorganized the courts around him. New laws came. He applied them. 1942, sentencing in the People's Court shadow. By 1942, Karl had moved to a higher regional court. He was not in the infamous Volksgerichtshof, the People's Court, under Roland Freisler. He did not shout at defendants. He spoke calmly, in technical language, as he convicted a Jewish man for Rassenschande, forbidden relations with a German woman. Sentenced a factory worker to years in prison for Wehrkraftzersetzung, undermining military morale after he had called the war lost, in front of colleagues. Approved confiscations of property under racial and political laws. The criminal code he applied was laced, bit by bit, with new paragraphs: Heimtücke Gesetz, treachery law. Heimtücke Gesetz, treachery law. Volksschädlingsverordnung, people's pest regulation. Lawyers complained quietly that these terms were vague, dangerous. Karl framed them as legislative choices of the sovereign. In a 1943 judicial conference, when a colleague expressed unease, he replied, "We do not make politics. Parliament and Führer make the norms. We examine facts, apply norms, that is our duty." The logic seemed watertight. It would later drown him in guilt. Capitulation and the first purge that wasn't. May 1945. Germany surrendered. The Nazi state collapsed. Allied powers assumed control. In their directives, they declared Nazi laws invalid where they contradicted basic human rights. Nazi organizations dissolved. Nazi judges subject to removal. At first, it seemed the profession's reckoning had arrived. American, British, and French authorities suspended many judges, established denazification panels, demanded question-artsification panels. demanded questionnaires listing all memberships, positions, activities. Karl filled out his Fragebogen, the infamous 31-question form, with lawyerly precision. Party membership, yes, from 1937. SA or SS number, role in political trials, ordinary criminal cases only. This last line was, at best, incomplete. But in a stack of hundreds of forms, his did not stand out as uniquely damning. The Allies soon faced a practical problem. Germany's legal system was shattered. Law codes needed revision. New democratic crime and black market activities surged amid hunger and chaos. They needed experienced jurists. The question became not whether former Nazi judges would return, but which ones and how quickly. Denazification, categories determined, internment or paper versus guilt in practice. Denazification tribunals in the Western zones developed a 5-étier system: 1. Major offenders, 2. Offenders, 3. Lesser offenders, 4. Followers, Mitläufer, 5. Exonerated persons, the categories determined, internment or prison. Loss of pension. Eligibility for public office. Prosecuting judges for applying laws democratically passed, however monstrous, raised difficult questions. Could you criminalize judging itself? Where did personal responsibility end and just following orders begin? Allied prosecutors focused on the most egregious cases: people's court judges, direct involvement in mass executions. Thousands of others, like Karl, passed through denazification with minimal penalties. In 1948, his Spruchkammer Denazification Court classified him as Mitläufer, a follower. The reasoning cited no evidence of personal cruelty or excessive severity. Participation in Nazi organizations primarily for career reasons. No leadership role. He was fined a portion of his assets, temporarily barred from high judicial office, but allowed to work as a legal advisor. Privately, he noted the irony. The law that once condemned petty thieves now judges me. Yet the sentence is mild. Perhaps I am less dangerous than a hungry man who stole potatoes. The Cold War and the quiet rehabilitation. By 1949-50, geopolitical priorities shifted decisively. The Western Allies now saw West Germany as a bulwark against the Soviet bloc, a future member of Western alliances. Stability became more important than thorough cleansing. Konrad Adenauer's government argued that the new democracy needed continuity in administration, could not function if everyone with a party membership was barred. Under pressure from conservative politicians. Professional associations. Laws were passed to restore pensions, shorten or end bans from public service. In 1951, the 131 Gesetz allowed thousands of former Nazi public servants to return to state employment. For the judiciary, this meant former judges and prosecutors could reclaim robes. Past service counted towards seniority and pension. Karl's old colleagues reappeared in corridors. Some had spent a year in internment camps. Others had never left. One joked, in a way that was not a joke, "We changed the flags above the courthouse. The desks stayed in the same place." By 1954, Karl's record, re-examined in the new political climate, was judged unproblematic. He received his appointment as presiding judge. The letter referenced his long experience and professional competence. It did not mention the opinions he had signed from 1939 to 45. The new cases, petty crimes, old patterns. On a typical day in 1954, Karl's docket might include a young man charged with stealing coal from a rail car, a woman accused of illegal foreign currency possession, a bar fight. The death penalty, abolished by the new Basic Law, no longer hung over the courtroom. Defendants had, defense lawyers who could appeal to constitutional rights, a federal constitutional court in Karlsruhe stepping in when lower courts violated those rights. On the surface, justice had been domesticated. Germany now proudly cited the rule of law, human dignity as the supreme value. But beneath this, continuities persisted in the personnel, the attitudes. Karl had once been admired for his firmness against enemies of the Volk. Now he was praised for firmness against enemies of the Volk. Now he was praised for firmness against criminals who threatened social order. The vocabulary changed. The reflex, the instinct to protect the state from perceived disorder, remained. The man in the gallery who would not look away. One winter morning, during a routine theft case, Karl noticed a man in the public gallery staring at him with unnerving intensity. Grey hair, thin build, cheap suit, hands clasped tightly in his lap. Throughout the hearing, the man did not look at the defendant, the lawyers, or the clerk. He looked only at the bench. After adjournment, as Karl exited by the side door, the man approached. "Do you remember me, Herr Doctor?" he asked, voice shaking. Karl searched the face, came up empty. "In 1943, the man continued, you sentenced me to 5 years at hard labor for listening to the BBC. Wehrkraftsversetzung, you called it. My wife hanged herself the week after." Silence filled the corridor. A younger judge passing by froze, then hurried on. Karl answered with the only line he had repeatedly rehearsed in his mind. "I applied the law as it stood. I could not change the law." The man laughed, a brittle sound. "You cannot change what you did either," he said. He did not shout, he did not strike, he simply turned and walked away. Karl later wrote, "The archives may not hold every file, but the people I judged carry the sentences in their bones." Legal continuity, the code that never fully broke. One of the strangest features of West German justice was how much of the old criminal code remained. The Strafgesetzbuch, heavily modified under the Nazis, was not thrown out wholesale. Paragraphs directly tied to racial law were voided, but many vague offences remained on the books, including public insult to the state, immorality clauses. Nazi interpretations had stretched these to absurdity. Now, judges trained in that era interpreted them more cautiously, but their default respect for state authority persisted. Legal historians would later point out, only a small fraction of Nazi-era judgments were formally overturned. Many draconian sentences remained valid on paper, even as victims struggled for recognition. In conferences, older judges like Karl insisted, "We must avoid two extremes, returning to Nazi injustice and descending into Weimar chaos. Firmness with moderation, that is our path." The phrase Weimar chaos served as a warning. Too much leniency, too much political tolerance might invite another collapse. Thus, under the banner of never again, some old reflexes were justified anew. The few prosecutions and the silent many. In the 1950s, a handful of high-profile trials targeted Nazi crimes, camps, Einsatzgruppen, certain SS doctors. Judges and prosecutors rarely sat in the dock. When they did, defense strategies often succeeded. We acted under valid law. We would have been removed or imprisoned if we refused. Courts, staffed largely by the same profession that stood accused, were often sympathetic. They distinguished between excessively cruel judges may be punishable, normal judges applying harsh laws, exculpated. Karl watched these trials with professional attention and personal dread. He underlined passages in rulings that confirmed his exoneration. The mere application of unjust laws does not in itself constitute a crime, unless combined with personal excess. He had not shouted. He had not gloated. He had spoken calmly while imposing ruin. The law now declared this insufficient for conviction. He was safe. But safety did not equal peace. The young defense lawyer who had read too much. In 1958, a new generation entered the courts. Lawyers born during the war or in its early years, educated in a federal republic, starting to confront its past more openly. One such defense attorney, representing a factory worker accused of assaulting a former Nazi foreman, requested access to old personnel files. He discovered Karl's prior positions. In cross-examination, he asked, politely but pointedly, "Herr Vorsitzender, may I inquire whether you presided over political cases under the previous regime?" The prosecutor objected. "Relevance," the defense argued. "My client is accused of violence against a man who calls himself a victim of denazification. We must understand the context of how justice works in this court." Karl shut down the line of questioning. "The court's past is not on trial. We are here to decide this case according to present law." Later, the young lawyer wrote an article in a small legal journal, anonymously. "Many of our senior judges sat comfortably through 1933-45, applying unjust laws as if they were natural. Now they sit comfortably in 1958, claiming continuity of legal culture. What they call continuity, we might call contamination." Few read the article. Those who did, in senior positions, dismissed it as youthful arrogance. Archives as battlefields. What was burned? What survived? In the immediate post-war chaos, many court archives had, burned in bombing, been deliberately destroyed, been misplaced in hasty evacuations. This convenient loss made it difficult to reconstruct exact roles. Karl's most incriminating files, his signatures under death sentences, had vanished in a 1945 fire at the Justice Ministry building. He told himself this was fate, not design. Others were more proactive. Files weeded by sympathetic clerks. Personnel records cleaned before Allied investigators arrived. Historical commissions decades later would uncover traces, references in surviving ledgers, citations in Nazi law journals, newspaper reports from the era. But in the 1950s, much remained in shadow. Karl knew that absence of documentation had shielded him. He also knew that for those whose relatives had never returned from prisons and camps, the lack of paper did not mean lack of memory. "The state may forget by losing paper," he wrote. "People forget, if at all, by losing years. I sit in a courtroom and watch that forgetting happen case by case. The victim as defendant, role reversal without justice. Occasionally, someone who had once stood before Nazi courts now appeared again, this time as a defendant or witness in an ordinary case. A man prosecuted for tax evasion who had been imprisoned in 1941 for sabotage. A Jewish merchant suing for restitution against a German buyer of his expropriated shop. These proceedings revealed how incomplete the break with the past was. Restitution laws were complicated, hostile in practice. Burden of proof often fell on victims. Deadlines were tight. Bureaucratic obstacles plentiful. Judges like Karl, now applying these laws, had wide discretion, interpret documents narrowly, deny claims, interpret generously, acknowledge prior injustice. Many chose the former, citing legal certainty and economic stability. In one such case, a Jewish plaintiff, denied full compensation, told the court, "You stole with laws then. You keep with laws now." No one recorded her sentence in the judgment. The transcript noted only, "Plaintiff expressed dissatisfaction." For Karl, these moments were harder to forget than any political speech. The myth of the hour zero and the reality of long shadows. Official narratives in the 1950s spoke of Stunde Null, hour zero, A new beginning in 1945, a break with everything that came before. In reality, institutions did not reset to zero. Universities retained professors who had written for Nazi journals. Ministries rehired civil servants who had drafted racial laws. Courts were led by men who had managed justice under the dictatorship. The Federal Republic did introduce a liberal constitution, strong protections for civil rights, a constitutional court willing to strike down unjust statutes. But at the daily level, where most citizens encountered the law, fines, lawsuits, local criminal cases, continuity in faces and habits mattered as much as text. Karl embodied this paradox. He was, by the 1960s, seen locally as respected, strict but fair, a man who opposed communism and defended property rights. Schoolchildren on courthouse tours saw his robe and gavel, not his party membership card. The past did not disappear. It sank below the surface, visible only to those who looked closely. Late self-interrogation. A judge judging himself. In his 60s, after retirement, Karl finally allowed himself to write honestly. Not for denazification panels, not for personnel files, but for himself. He reread old legal journals from the 1930s and 40s. He saw his own articles arguing for harsh treatment of underminers, citations of his judgments as examples of sound National Socialist jurisprudence. He no longer had to fear professional consequences for acknowledging what they meant. In a long, unsent letter addressed to "my successor on the bench," he wrote, "You will inherit a courtroom whose walls have heard sentences under 3 regimes: empire, dictatorship, republic. Do not believe any of them were free of injustice. In my time, we clothed injustice in the language of legal positivism. The law is the law. This was cowardice disguised as professionalism. When the law commands what is manifestly inhuman, you must disobey. I did not. For this, no denazification certificate absolves me." The letter remained in his drawer. He never showed it to the young judges who replaced him. He had spent a career silencing uncomfortable questions. He did not quite learn how to pose them aloud. The mathematics of continuity. How many were like him? Post-war research would later quantify what contemporaries only sensed. In some federal states, over 2/3 of high-ranking judges and prosecutors in the 1950s had already served under Hitler. Former Nazi Party members occupied a majority of leading judicial roles well into the 1960s. This was not a series of anomalies. It was a pattern. The Federal Republic's legal system, which would later prosecute Auschwitz guards and commandos, had been initially reconstructed by men who had once enforced racial law and draconian war decrees. Some evolved. Others adapted without deep reflection. A few, like Karl, ultimately confronted their conscience privately. The system never demanded it publicly. It demanded only loyalty to the new constitution. Professional competence. Moral self-examination remained optional. Rehabilitated in law, not in memory. The term rehabilitated appeared in personnel decisions and denazification reports. It meant the state considered someone fit for office again. Prior political affiliations were no longer obstacles. For those who had stood before Nazi courts or whose relatives had not returned, the word had a different taste. They did not see rehabilitation. They saw a judge who had once pronounced, "in the name of the German people," doing so again, under a different coat of arms. A continuity of faces where there should have been, perhaps, a new generation. In his final notebook pages, Karl acknowledged this gap. The Federal Republic made a rational calculation. It needed courts, so it hired judges. It needed peace, so it avoided too much looking back. The price was that men like me were allowed to grow old on the bench instead of in the dock. I am rehabilitated in law. I will never be rehabilitated in the eyes of those who remember my sentences. Civil life after the war for such a man was not a clean break from dictatorship to democracy. It was a long walk along a corridor whose doors bore different signs but led, disturbingly often, to the same rooms. The courtroom as mirror, what remained after he was gone. When Carl died in the late 1960s, the local newspaper published a brief notice. Long-serving judge, respected for his integrity and dedication, has passed away. Colleagues attended the funeral. Obituaries mentioned his careful reasoning, his service in rebuilding the judiciary. They did not mention his wartime sentences, his denazification file. Decades later, historians poring over fragmentary archives and survivors' testimonies would reconstruct men like him as part of a broader pattern. They would argue that West German democracy ultimately became stable and liberal, but began with a compromised foundation in its courts. The story of the rehabilitated Nazi judge is not mainly about one man's guilt. It is about a system that chose continuity over rupture, technical competence over moral scrutiny. In 1954, when he wrote, "They burned my past from the archives, but not from the eyes of those who remember," he captured a central tension of post-war German life. The state could stamp "cleared" on his file. It could assign him a bench and a pension. It could ask citizens to trust the robe again. It could not command memory to obey.